we're back on the record. Both parties have returned. Been informed all jurors are present. Do we have anything that I need to address before we bring them back in?
Nothing from the state.
Nothing from the bench, Your Honor.
All right, let's go ahead and bring the jurors back in and we'll resume the trial. All right, seat. All right, ladies and gentlemen, welcome back. I trust you had enough time for lunch and that you all complied with the instructions of the court. You didn't do any research looking up of anything, didn't do any investigation of your own, correct? All right, and did anybody associated with this case have any contact with you during the lunch break? No? All right, then we are ready to resume. State, you may call your next witness.
Yes, Your Honor. At this time, the state calls Dr. Marie Hansen.
Do solemnly swear affirm testimony shall give the truth, the whole truth, and nothing but the truth, so help you God.
All right, can you go ahead and state your full name for me and spell your first and last name for the court reporter, please?
Dr. Marie H. Hansen, Mariehansen.
State, you may inquire.
Thank you, Your Honor. Good afternoon.
Good afternoon.
If you could just introduce yourself to the jurors.
I'm Dr. Hansen. I'm an associate medical examiner at the District 9 and 25 Medical Examiner's Office. And I'm a forensic pathologist, which means I'm a medical doctor. I'm a pathologist. I did 4 years of anatomic and clinical pathology residency. And then I did a forensic subspecialty residency and have passed the national board exams, and thus am board certified in anatomic, clinical, and forensic pathology.
Thank you, Doctor. And if you could just give the jurors a little bit of your educational background to hold your current position.
I have a BS in chemistry from the University of Wisconsin-La Crosse. I have a medical degree from the University of Minnesota. I have an anatomic and clinical pathology residency in St. Paul, Ramsey, and I have a forensic pathology residency in Miami, and I've been a practicing medical examiner since 1990.
Now, your current position in Orange County, how long have you had that position?
Since November of 2002.
And in that position, do you have to undergo periodic continuing education?
Yes.
And are you up to date with all the required continuing education?
Yes.
Now, as part of your work as associate medical examiner, is part of your job to perform autopsies?
Yes.
Can you describe to the jury what an autopsy is?
An autopsy is a gathering of history and then looking at a person, documenting the external surfaces of the body, looking for evidence of injury, evidence of natural disease, and evidence of medical intervention, and then continuing internally to look at the organs, looking for evidence of natural disease, evidence of injury, and taking specimens as appropriate for potential chemical analysis to help determine the cause and manner of death.
Now, in what circumstances is an autopsy conducted?
Under State Statute 407, any unattended death or any potential trauma, accident, suicide, or homicide, or an undetermined death would be reviewed. If somebody has been in an accident and has been in the hospital for a week, week and a half, they may have done enough documentation that we can tell why they died, and they may not need an autopsy. But in cases of homicide, almost everybody gets an autopsy.
And are you able to provide a rough estimate, I know you don't have the exact number, of how many autopsies you've conducted in your career?
Roughly an average of 250 to 300 a year since I've been practicing.
And that's going back to 1990?
Yes.
All right. And I think you mentioned autopsies are a tool to determine the cause and manner of death. Can you just explain to the jury the difference between a cause of death and a manner of death?
A cause of death is a physical disease or a physical injury that causes a person to die. Manners of death are natural, due to natural disease, accident, most often car accidents or drug overdoses or drownings. Suicide, again, that can be drugs, that can be hanging, that can be shooting yourself, other inventive means as people invent, and homicide, deaths due to actions of another, as well as undetermined. Based on the information we have, we can't tell.
Now, when you conduct an autopsy, are they assigned specific case numbers?
Yes, they are.
And as part of your job duties, did you conduct an autopsy in case number ME 2022-909 on a person identified as Adreian Payne?
Yes, I did.
When was that autopsy conducted?
That was conducted May 10th, 2022, beginning at 9:15 in the morning.
Now, was that autopsy documented with photographs?
Yes, it was.
Have you had a chance to review your photographs or the photographs from that autopsy prior to today?
Yes, I have.
Let the record reflect I'm showing opposing counsel with the mark for identification as K.
You said K?
Yes, Your Honor. Now, as part of the documentation of an autopsy, is there typically a photo of just the deceased's face that's taken? It's like an identification photo?
Yes. A cleaned up picture of the face straight on for possible use in identification if it's necessary.
Ready to approach?
You may.
Let the record reflect I'm showing the witness with the mark for identification as states K. If you could take a look at that. And is that the identification photo that was taken in this case?
Yes, it was.
And is that a fair and accurate depiction of the deceased as he appeared at autopsy?
Yes, it is.
At this time, the state offers into evidence what's been previously marked for identification as state K.
Any objection? No objection. What's been marked as States Exhibit K for identifications received into evidence without objection as States 11.
Written published.
You may.
Now publishing state exhibit 11. And is this, as we discussed, the identification photograph taken of Adreian Payne in this case?
Yes, it is.
Now, were there other photos taken during the course of the autopsy showing wounds suffered by Mr. Payne?
Yes, there were.
Let the record reflect I'm showing opposing counsel with the mark for identification as states composite L. Permission to approach?
You may.
Let the
Yes, these are a selection of the photographs.
And are they fair and accurate?
Yes.
At this time, the state offers what's been previously marked for identification as L and
Any objections?
No objection, Your Honor.
What's been marked as State's Exhibit L for identification without objection from the defense is received into evidence as State's 12.
permission to publish.
You may.
Give you a laser pointer so you can walk us through these a little bit better. What are we looking at in this photo?
This is a photo of a front-on photo of Mr. Payne. And you can see the head, the chest, and the upper arm. And in this particular picture, you can see the nipples are right and left, and he has a defect in his arm and a defect in his chest. And he has some abrasions from resuscitation artifact.
So you circled with your laser pointer in the middle of his chest. So that would not be something from attempted resuscitation.
Yes, this would be consistent with doing CPR.
And can you just point out in this photograph for the juror what you believe to be the wounds sustained in this case?
Somewhat in the shadows, but you have 2 wounds on the arm and 1 on the left chest.
Can you describe what we're looking at here?
This is the entrance wound in the arm, the exit wound in the arm, and the re-entry into the chest.
This is just the same wounds, but now with measure for scale.
Yes, we're measuring it to scale and the characteristics.
This is again a closer view.
Yes, this is a closer view of the wound through the arm.
What are we looking at here?
In this particular case, when we examined him in standard autopsy position with his hands at his side and his palms up, the wounds do not align, but if you lift the arm and turn it slightly, then the wound through the arm continues into the chest and continues down in through the body.
And then this is just a photo of the left hand of the victim.
Yes.
Did you observe anything of note on the left hand?
No. We are looking for contusions, lacerations, chipping of the fingernail.
Is this the right hand?
Yes, this is one of the set of 4 for the right hand.
Did you observe anything of note regarding the right hand?
No.
What are we looking at in this photo?
This is a photograph of the projectile that we recovered from the right abdomen.
So during the autopsy, while you're performing the autopsy, is it correct that you actually withdrew this projectile from the body?
Yes, I did. And we're looking at a sort of cleaned up, this is the top. You can see that it has gotten into a star shape instead of, so it's a deformed tip. And you can see it has a little bit of a copper backing. And we have it from different angles, so you can see the deformity of the tip, the core, and then the jacket In the back, you can see that it is a yellow metal fire jacket.
Now, the photos that we just saw of the projectile, did you actually package the projectile up for evidentiary purposes?
Yes, we would package it place it in a small vial and put a label on it from the case, and then I'd seal it and sign the sealing of that.
Would you be able to recognize that from just the packaging, or would you need to open it?
Not from the outside packaging, because then it gets to law enforcement and they put it in multiple manila envelopes and
You may.
Showing the witness was compared to evidence as Exhibit 8. You just take your time and open it up. Let me know when you've been able to get to a point where you can recognize that.
I can see and recognize what I signed.
So is this, in fact, the projectile that was removed from Mr. Payne during the autopsy by you?
Yes, it was.
You can remove it. Now, as part of your work conducting autopsies, is it helpful for you to use diagrams? And would that be helpful in describing the autopsy to the jury?
I believe it would.
Let the record reflect I'm showing opposing counsel for mark identification as states M. Wishing to approach?
You may.
Let the record reflect I'm showing the witness for mark identification as states M. Let me know. Are those diagrams done as part of the autopsy in this case?
Yes, they are.
At the time the state offers into evidence what was previously marked for identification as state M.
That's M as in like Mary?
M is in, no.
Okay, just want to make, all right. What's been marked as State's Exhibit M for identification without objection from the defense is received into evidence as States 13.
Mr. Publish.
You may.
What are we looking at here?
This is a diagrammatic representation of what you saw in the photographs, and I used a clear circle for the entrance and solid circle for an exit, and so the wound went from the arm, through the arm, misses the humerus, so it just goes through the soft tissue, then it goes into the chest, so that's a circle, and it goes diagonally, it goes through the lung, through the aorta, through the heart, and the other lung, and through the diaphragm, and we recover the projectile, that's the X. Just between the liver and the side of the abdomen.
You have a second diagram. If you could describe this for the jury.
And in the standardized options that are available for me for the diagram, when you raise the arm, you can see that you can make it in an alignment so that it goes in a straight line through the arm, through the chest, and into the body.
Now, based on your experience as a medical examiner, with the positioning of the victim's arm, based on the trajectory you were able to determine to be consistent with having your hand on a steering wheel?
It could be anything that puts the arm anterior and a little bit above. So it's in a line with the wound through the chest.
Would that also be potentially consistent with having your arm on like a window of a car or, window of a driver's side door?
Any position that's going to, any potential scenario that's going to get your arm up and a little bit anterior to the chest.
Now, based on your autopsy, were you able to determine a range of fire?
It appears to be a distant gunshot wound that's more than 2 to 3 feet away because there's no soot, there's no powder tattooing, and there's no the gunpowder that's coming out of the end of the gun to cause the explosion, to cause the bullet to go down the gun, comes out in a cloud with the gun, with the bullet. When it gets out of the gun, if you're close enough, it lands on the environment. And it was not on him.
So you're able to tell based on certain things like soot and other things if it's a close range gunshot. Is that fair to say?
That's correct.
But if it's beyond 2 to 3 feet, is that all just sort of the same category?
Yes. Once you get distant, once you have none of that, then it's at least 2 to 3 feet, and exactly how far may be determined by other investigational factors.
Now, as part of an autopsy, is a toxicology or drug screen run?
Yes.
Did the victim in this case have any drugs or alcohol in his system?
No, he did not.
And as part of your autopsy, do you weigh and measure the deceased?
Yes.
What was the weight of the deceased?
He was 247 pounds.
And how tall was he?
He was 80 inches or 6 feet 8 inches.
Now, in your autopsy in this case, were you able to determine a cause of death?
Yes.
What was the cause of death?
A gunshot wound of the arm and chest.
And were you able to determine a manner of death?
The manner of death is homicide.
Thank you. I don't have any further questions.
Ross?
Yes, Your Honor. Good afternoon. How you doing, Doctor? How you doing today?
Good afternoon.
Very good. Just briefly, you stated that this trajectory of the bullet wound was consistent with an arm being kind of raised in this type of manner?
Raised and a little bit anterior.
Okay. Something like, if I was to try to give you an example, can you see me? Would this be consistent?
Yeah, it's potentially consistent, yes.
Thank you. So could this type of bullet wound be the result of someone attempting to raise their arm up potentially? You mean what I'm saying? Someone potentially raising their arm up? Could this type of interior?
If they're raising their arm up as the gun is fired, it potentially could get. It could already have the arm up, or it could be in the process of raising it up. And when the bullet goes through the arm, that's.
Thank you. No further questions.
You redirect?
Briefly. So if an arm was raised, as counsel just demonstrated, where would the hand be positioned based on the trajectory you were able to do in the autopsy?
Well, can be a number of potential. All I can tell you is the position of the upper arm relative to the chest. The hand would be out in front if you don't have, if somebody has their palm up, you could have your palm up, you could have your palm down, you could have your hands. In this particular case, it's a little bit better if it's twisted so that the thumb is down. Twist the arm to get in the in and out hole in the right line.
So obviously, just sort of anatomically, a person, when they have their arm up, it can only extend out this far, right? They can't go backwards at the elbow.
No, you can only go as far as your elbow will go.
So to be in the position that you were able to determine from the autopsy, if the arm was up, it couldn't be going back this way. It would be just facing this way or in this way, as I'm demonstrating.
Yeah, the arm would be in front because you can't make the hand go back without the arm being in a different position.
Thank you. I don't have any further questions.
All right, may the witness step down?
Yes, Your Honor, thank you.
All right, thank you. All right, state for your next witness.
Yes, Your Honor. At this time, the state calls Kristen Killinger.
You solemnly swear affirm testimony shall give, shall be the truth, the whole truth, nothing but the truth, so help you God.
All right, go ahead and state your full name for me and spell your first and last name for me.
My name is Kristen Killinger, Kristen, Killinger.
All right, state your main inquiry.
Thank you, Your Honor. Good afternoon.
Hi, good afternoon.
If you could just introduce yourself to the jury.
My name is Kristen Killinger, and I am employed by the Florida Department of Law Enforcement in the Orlando Regional Operations Center.
And what is your position with the Florida Department of Law Enforcement?
I am a crime laboratory analyst in the Firearm section.
How long have you held that role?
I have been a crime laboratory analyst for about 5 years.
And have you had any other job titles, or have you had the same job title throughout your time there?
I have been at FDLE for 7 years. I was a forensic technologist in the trace materials section and also in the firearm section, and then I was promoted to crime laboratory analyst.
And in your current role, what are your job duties?
As a crime laboratory analyst, I primarily test firearms to see if they're functional or not. I will also do microscopic comparisons with fired ammunition components, such as bullets and cartridge cases.
If you could just give the jury your educational background to hold the current position you have.
I have a Bachelor's of Science degree in forensic science from the University of Central Florida. I also completed a 2-year training program in firearms identification.
Now, as part of your job with FDLE, do you have to have ongoing training to keep up to date?
Yes, I complete continuing education.
And are you up to date with all of the necessary continuing education to this point?
Yes.
Now, I want to take you back to January of 2023. Were you still employed with FDLE at that time?
Yes, I was a crime laboratory analyst then.
Did you become assigned to be the analyst in this case involving defendant Lawrence Dority, FDLE case number 2022-0506229?
Yes, I was.
So what were you asked to do in this case?
For this case, I received a firearm and a projectile, and I was asked to compare the projectile to the firearm if possible.
Were you also able to test the firearm to determine if it was functional?
Yes, I also did a functionality test on the firearm.
Can you describe to the jury what a functionality test is?
Yes, so when I receive the firearm, I will kind of look it over, document it, take notes on what I have, such as the make, the model, the caliber, the features that the firearm has. I will examine the firearm to make sure that it's safe for me to test fire. And then when I do feel like it's safe, I will take it onto our laboratory range. And in this case, I test fired it into our water tank, which is just a tank full of water. That way I could recover both the cartridge case and the projectile from the firing process.
And in this case, you yourself actually fired the firearm?
Yes, I did.
And was it functional?
Yes, it was found to be functional.
Now, regarding the projectile that you were sent, what were you tasked to do regarding the projectile?
For the projectile, I was asked to compare it to the firearm if possible to see if the projectile was fired from this firearm.
How was that done?
So I use a comparison microscope, which is just a microscope that has 2 stages, so I can view 2 things at the same time in the same field of view. So in this case, when I opened up the projectile, I documented what I had, and when I felt like I could move forward with a comparison, I took the bullet that I test fired into the water tank, and I compared it using my comparison microscope. I looked at the microscopic imperfections that are present from the firing process, and I compared the bullet that I received as evidence to the test-fired bullet that I fired into the water tank.
Now, these microscopic impressions, are they unique to each individual firearm? For like a fingerprint, is unique to an individual?
Yes, the firearm during the manufacturing process, the process of cutting the firearm to make it the shape that it is. There's rifling in the barrel that imparts the spin on the bullet for when it's traveling to spiral kind of like a football so it travels straight. The process of putting the rifling into the barrel is like cutting metal. And so there's microscopic burrs and inside of the barrel there's little metal burrs and flakes that are inside that will leave microscopic imperfections on the bullet during the firing process.
Your Honor, permission to approach with what's already in evidence as State 7 and States 8.
You-
Okay.
Let me know once you've had a chance to look at them.
Okay.
Is that you have in front of you the firearm that you were sent to do the analysis on in this case?
Yes, it is.
And is in the manila package, is that the projectile that you did the analysis on?
Yes, it is.
And were you able to make any associations with that firearm and that projectile?
The projectile was identified to the firearm.
Now, when you say identified to, does that mean that that projectile that was removed from the victim in this case was fired by the firearm that you have in front of you?
Yes, it was.
I don't have any further questions.
Cross?
I have no questions for this witness.
All right, may the witness be excused?
Yes, Your Honor.
All right, thank you, ma'am. You can step down.
Thank you.
All right, state your next witness.
Your Honor, at this time, the state rests.
All right, ladies and gentlemen, the state has rested its case. There are some legal matters that I need to address outside of your presence, so I'm going to ask you to step into the jury room while I address those, and then when we're ready, we'll bring you back in, okay?
All right.
right, have a seat. Any motions or matters that I need to address from anyone or any party as it relates to the state resting its case?
Yes, Your Honor. If I may have a moment, at this time, defense would like to move for a judgment of acquittal, and this is the basis for that. As related to the charge, it appears that the state has charged my client, Mr. Lawrence Dority, with second-degree murder with a firearm. Okay, carries a 25 life minimum mandatory, and as a necessary element, the state is required to prove an element that by an act imminently dangerous to another and evincing a depraved mind regardless of human life, Lawrence Dority did kill Adreian Payne. And during the commission of said offense, Lawrence Dority did carry, display, use, threaten to use, or attempt to use a firearm. And Lawrence Dority actually possessed a firearm or destructive device. Lawrence Dority actually discharged a firearm or destructive device. And the result of the discharge of the firearm or destructive device, death or great bodily harm is inflicted upon Adreian Payne. And viewing the facts in the light most favorable to the state of Florida, Your Honor, I believe the state has failed to establish by competent and substantial evidence in regards to the necessary element of an act being imminently dangerous to another and demonstrating a depraved mind. The reason why I make this position, Your Honor, is that by definition, just going to the jury instruction, an act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and, not or, and, meaning they have to also establish and is done from ill will or hatred or spite or an evil intent, and, not or, and, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, although it's not necessary for the state to prove the defendant had intent to cause death, the issue in this case is whether, as it relates, if you're viewing the facts of this case in the light most favorable to the state, obviously we're raising self-defense, we haven't got to that point, but if you're viewing it in the light most favorable to the state, alternatively, the state would have to still establish during their case in chief that Mr. Lawrence Dority acted with depraved mind, all right? And absent in this situation, the only alternative that would seem to support the facts as we are listed, or as we stand right now, the issue is whether Lawrence Dority did not have a depraved mind without regard to human life because he acted in the heat of passion based on adequate provocation. That's an issue in this case, Your Honor. So in order to find that he did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person. And a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was no reasonable amount of time for a reasonable person to cool off. And a reasonable person would not have cooled off before committing the act that caused death. And that Mr. Lawrence Dority was in fact so provoked and did not cool off before he committed the act that caused the death of Mr. Adreian Payne. And that's what I believe the facts, at best, if we're looking at the facts of this case in the light most favorable to the state of Florida, they have not established a second-degree murder with firearm, at best, in viewing the light most favorable to the state. What we have, because the facts support that this was a heat of passion, if we're viewing it in the light most favorable to the state, right? This is manslaughter, at best. Mr. Dority didn't have a relationship with Mr. Payne. He only knew of the man's name through his association with his girlfriend over the years. There was no evidence that he had a prior incident with him. any riff, any text, any call, any exchange, any prior situation. All you know, he's coming home and he's surprised by a person he doesn't have any affiliation with, and they have an altercation of words. He's feeling threatened. Well, from our position, we're saying he's feeling threatened. I know you haven't heard from my client yet, but the evidence still supports that there was an argument. And he went into his home. This is at 1:30 in the morning outside his house. And even by testimony of Ms. Tara Walker, she states that Mr. Dority asked, "Why are you here?" So what we have here is a spontaneous situation. But he didn't have time to cool off, because whatever the exchange was, it immediately resorted to Mr. Dority having to go back into his home and come back out and ask again, "Why are you here?" While his son is outside, his dad is outside, and they haven't made it safely into the home yet. So at best, Your Honor, this is not second degree, at this phase, this is not even second degree murder with a firearm. I would submit to the court, this is overcharged to begin with. Based on that, I believe that element, based on that lack of sufficient establishment of that necessary element, that you must give us a judgment of acquittal as it relates to second degree murder with a firearm.
Okay.
Your Honor, the defendant's actions in this case speak for themselves. He went after someone was not on his property but was parked down the street. He engaged that person in words. He then stormed into his house, armed himself with a firearm. During this time, he didn't, cool off, or he had certainly had time to do that. He then armed himself with a firearm. He came out. You heard the video of Tara Walker screaming for him, "Don't take your gun out, don't do this, Lawrence." And then he still, after all of that, in that circumstance, aims his firearm at the victim in this case and shoots and kills him. This certainly meets the elements of second degree murder. It doesn't require an intent to kill, but a depraved mind. Certainly, anytime you point a firearm and discharge it at a person in this circumstance, that shows ill will, hatred, spite, or evil intent. And again, that portion of the depraved mind is or. So it could be an ill will or a hatred or spite or evil intent. And then obviously shooting a firearm at another person is clearly indifferent to human life. So we've met the elements of second degree murder and ask that you deny the JOA.
Your Honor, may I add something briefly?
Good.
In light, regardless of what the state just mentioned, still sufficient facts that gives the fact finder a reasonable understanding of what Mr. Dority was placed in at that time, that situation. You heard from the expert that the trajectory of how the bullet went through his bicep to go into his chest cavity is consistent and could be because he was raising his hand, arm up. Now, the issue is, why was he raising his hand up? In the direction of where, if his thumb is down, Your Honor, he could have been holding his gun like this, or trying to. That's enough right there to not allow second degree murder with a firearm to proceed, Your Honor, if you're viewing the facts in the light most favorable to the state of Florida.
Wasn't there testimony that from one witness that his arms were up and he was in between the driver's door and the driver or the hood of the car? And that's a fact that is in the light most favorable to the state, that the arm is already up?
That doesn't negate that if his hands is up, he could have had a weapon in his arm, in his hand as well.
Understood.
I understand Your Honor's position. Regardless of the fact there was no rift previous at the time of this situation. This is not something where he intended. I know he doesn't have to intend the outcome of death, but this is literally a heat of passion moment. It can be no other thing. And a heat of the passion killing by law is manslaughter. He didn't have time to cool off. Even the same witness that said Mr. Payne had his hands up also testified that Mr. Dority was in his house less than a minute minute at best, minute and a half at best. That's not time to cool off when someone's outside your house at 1:30 in the morning threatening you while your child and your father's outside. You just got to finish celebrating Mother's Day. You're on your way home, and unknown to you, someone's lying in wait for you. And when you ask why you're here, you get a threatening posturing response. 6'8", 247 pounds. That's adequate provocation. Thank you.
All right, I'm going to take the matter under advisement. There's one thing that I want to check on, and then I'll be able to rule on that issue, okay?
Thank you.
All right, does the defense wish to present a case?
Yes, Your Honor. The defense would like to call Mr. Lawrence Dority.
All right, and any other witnesses?
With all candor to the court, I don't believe another witness is necessary. No.
Okay. All right, so a couple of things then, Mr. Dority. Your attorney has indicated that he's going to call you to testify. You understand that?
Yes, Your Honor.
All right, and he's indicated that he's making the decision not to call any other witnesses other than you for purposes of your case. You understand that?
Yes, Your Honor.
All right, have you discussed that strategy with him?
Yes, Your Honor.
And are you in agreement with that strategy?
Yes, Your Honor.
Okay, so you understand that after you testify, there will be no other witnesses or no other evidence presented on your behalf? Is that correct?
Yes, Your Honor.
All right. Then the jury will have to make its decision based upon the state's evidence and testimony from their witnesses and from your testimony. You understand? Okay. Now, have you had a discussion with your attorney about the pros and cons of testifying?
Yes, Your Honor.
Have you had a discussion with your attorney about the pros and cons of not testifying?
Yes, Your Honor.
Okay. You understand that if you take the witness stand and you testify, that you're going to be treated just as anybody else who takes the witness stand, meaning that the jury's going to get to assess your credibility just like they did everybody else's, and the same rules that apply to their testimony will apply to yours. All right. And you understand that you have an absolute right to remain silent if you want to.
Yes, sir.
Okay. And that if you were to exercise your right to remain silent, I would instruct the jury, as I did during the jury selection, that they are not to consider your decision not to testify against you in any way, shape, or form. You understand that?
Yes, Your Honor.
All right. Do you have any questions about your right to testify or your right to exercise your right to remain silent?
No, but is there a way that I could talk to my lawyer for a couple?
Certainly. Go ahead and talk to him, and then I'll follow up. All right, you've had a chance to continue or to consult with your attorney.
Yes, Your Honor.
Do you need any more time to do so with him?
Sir, is there a way I can take a bathroom break before?
Oh, we're going to do that. Don't worry. And so, do you have any questions for your attorney or for the court about your right to testify?
No, sir.
Do you have any questions for me or your attorney about your right to remain silent?
No, sir.
All right. And you've indicated to me that you've had the opportunity to discuss the pros and cons of testifying and the pros and cons of exercising your right to remain silent, correct?
Yes, Your Honor.
All right. After having considered those, have you reached a decision in this case as to what you want to do?
Yes, sir.
Okay, can you tell me what decision you've reached?
I want the people to hear my story.
All right, so you want to exercise your right to testify.
Yes, Your Honor.
Has anybody forced you, threatened you, or coerced you in any way to make that decision?
No, sir.
Has anyone promised you anything to make you make that decision?
No, Your Honor.
And are you making that decision because you believe it's in your best interest and you want to?
Yes, sir.
Okay. And is there any other witnesses or any other evidence that you want presented to the jury other than your testimony?
There is one thing
All right, have you discussed that with your attorney?
It's okay, Your Honor.
All right, so after consulting with your attorney about the issue that you were considering, you're advising me that you no longer wish to have any witnesses or evidence other than yourself testify, is that correct?
Yes, Your Honor.
Okay. All right, then what we will do is take about a 5 or 10 minute recess for everybody to use the restroom and whatnot, then we will come back and start with the defense case, okay? So we'll be in recess.